All right. I am pleased to welcome Christy Mallory, who will be starting our webinar today. Again, our webinar is Two Cheers for Bostock, What the Decision Means for the Future of LGBT Rights, Racial Justice, and Democracy. Welcome, Christy.
Thank you, and hello, good afternoon, everyone. My name is Christy Mallory, and I am the legal director here at the Williams Institute. And I'm very pleased to welcome you all to our webinar featuring Professor Cary Franklin, who will be presenting her recent scholarship on the Supreme Court's decision in Bostock versus Clayton County. I also want to thank our co-sponsors of this event, two UCLA law student groups who we work very closely with, Outlaw and the Queer and Trans People of Color Collective. And now I'd like to turn it over to Natalie Fox, who is the co-chair of Outlaw, to introduce Professor Franklin. Thank you so much, Natalie.
Hi, everyone. Welcome. It is my privilege to introduce Professor Cary Franklin. Here during my time at UCLA, I've had the opportunity to take Professor Franklin's class on law and sexuality, which was easily one of my favorite courses. Professor Franklin teaches and writes in the area of constitutional law, anti-discrimination law, and legal history. She recently joined us from the University of Texas and Yale Law, where she was a visiting professor. And she specifically focuses on the historical influences on sex, sexual orientation, gender identity, and racial protections in the US. She is also the current faculty director of the Williams Institute, which organized this amazing seminar. So without further ado, I would like to introduce Cary Franklin. And if you have any questions during the seminar, please use the Q&A function, and then we'll pop on and do questions and answers towards the end. Thank you.
Thanks so much, Natalie, and thank you all for being here. I am really thrilled to be here at UCLA and be at the Williams Institute and to be working with people who focus on LGBTQI+ issues. We are waking up every day in this country to new laws that are trying to deny gay and transgender people their rights and punish those who parent them, who care for them, who love them. And I'm just so grateful to be at an institution that's pushing back against these rights denying bills, and especially to be at a place that's producing such high quality evidence and data to refute the scaremongering, the fear-mongering out there in the country today. I'm really honored that I get to do this work, and I'm really thankful to all of you who are also doing this work, who are advocating in this area and learning about it. So thank you. I'm going to talk about my paper that I wrote about Bostock, but because this is my first talk as a faculty director at the Williams Institute, I thought I might just say a little bit about the background of this paper, about my research interests, about the kind of questions and legal puzzles that interest me. And I will start at the very beginning, which is to say, I initially went to graduate school to be an intellectual historian. And I wrote my dissertation on the women's suffrage movement, on the vote. Now, this is the time of the First World War, and the vote is being framed not just as the ability to cast a ballot at a polling place, but as one of the important pieces in the traditional heterosexual family, where the husband is in control and the wife and the children are under his dominion, and society proceeds in an orderly fashion. He has the vote because he represents the family. So some of the suffragettes who were arguing against this restriction of the vote were arguing that it meant more than casting a ballot. They were arguing that it meant that we were going to radically alter the family, employment law, sexuality, dress, and they understood the vote as the right to cast a ballot, but also equality more generally, and family on new terms, and new kinds of freedoms to live one's life as a political citizen, but also as a sexual citizen, and express oneself culturally, including one's gender. And I wrote about what happened when we got the vote, when women got the vote, and it was very unclear the scope the size of that right, what it entailed, what it transformed, and what it didn't. In the course of doing that work, I started reading a lot of contemporary gay and transgender scholarship, feminist scholarship, and saw that people were very interested in these questions today. In fact, it was coming up in courtrooms, and then I could keep writing about these issues that I cared about in a way that affected people's lives currently, which was incredibly exciting and tempting. So I went to law school, and I've spent my entire career asking these questions that really stem back from the time I started graduate school, which is, what does equality mean? What counts as discrimination? When we have rights against discrimination, what is the scope of those rights? What are we protected against? What do they cover? When the law says no discrimination on the basis of sex or race or sexual orientation and gender identity, what's prohibited? And what kind of claims can people make on those provisions? So this may be old hat to some of you, but I think it's always worth a reminder that for the last 40, 50 years, the court has had a fairly clear answer about what counts as discrimination. It has defined discrimination formally, facially, in such a way that the court has said discrimination is basically you put all the women over here and you put all the men over here, and it draws a line down the middle of them, and it formally discriminates between men and women. Or you put all the white people over here and you put all the Black people over here. And that is what's discrimination. Other kinds of claims don't get covered by the law. So let me give a couple of examples to illustrate how that works in practice. So Jim Crow, for instance, Jim Crow dies under this regime. You have separate water fountains, you have separate pools, you have separate schools. All of that's not allowed. It's a formal facial discrimination. Affirmative action also dies. That draws a formal distinction on the basis of race. And the court has likened that to Jim Crow because it takes the same form in the sense that it formally discriminates on the basis of race. Now, practices that have a strong racial disparate impact, and here I'm particularly talking under the Constitution, like the decision to fund schools through local property taxes, or to only allow single-family zoning, or to punish the use of crack cocaine 100 times more than the use of powder cocaine, when all of these things have a massive racial disparate impact, not discrimination, because they're facially neutral, because they don't formally discriminate on the basis of race. So the anti-discrimination law this court has given us says formal facial discrimination illegal. Other things that might have huge effects on people's lives are not violative of anti-discrimination law. Pregnancy. The court famously in the 1970s said pregnancy does not discriminate on the basis of sex because it doesn't divide men and women. It divides pregnant people from non-pregnant people. Non-pregnant people include men and women. In the court's view, pregnant people only included women, but that doesn't draw a line neatly between the sexes. And so that is not sex discrimination. You can think about the implications of this for the regulation of pregnant women, including abortion, where the court has had a very difficult time seeing the sex equality or sex discrimination dimensions of the regulation of abortion, or the racial equality dimensions of the regulation of abortion, even though those laws have enormous disparate impacts on the basis of race or sex. They don't formally distinguish, and so the court has not found them to be racially or sex-based discrimination. And then I'll come to the instance that has consumed much of my career so far, which is the effects of this conception of discrimination on gay and transgender people. So there are literally hundreds of cases where the court has said discrimination against gay people, discrimination against transgender people is not covered under our landmark civil rights statutes that bar sex discrimination, because these laws really aren't aimed as at women as a group or at men as a group, but they are aimed at gay people or transgender people They are not covered under the law. And the court has said, courts repeatedly ad nauseum in these cases, that we must implement the quote unquote traditional conception of sex discrimination. The traditional conception of sex discrimination does not cover SOGI. Okay, well, that took me aback when I first started reading those cases, because I wrote my dissertation about World War I, when two things were true. One, it was very ambiguous what sex discrimination protections covered. It was not set in stone. There was a lot of contestation about that question, about what the scope of sex discrimination was. And two, there was a general understanding that it had to do with the enforcement of traditional sex roles in such a way that it seemed that gay and transgender people could fit within a regime that bars sex discrimination. So I'm reading these courts starting in the 1970s, 80s, 90s, up through very recently, saying, sorry, gay and transgender people, you can be fired. You don't get any protection from discrimination because the traditional conception of sex discrimination only refers to men and women, and you are talking about a different kind of discrimination that did not comport with the history that I knew from being a historian in my past life. So a number of years ago, I wrote an article called Inventing the Traditional Conception of Sex Discrimination, in which I argued that courts invented this traditional conception, i.e. the formal conception where you have to have all men over here and all women over here, and it's women as a group or men as a group. And the courts are saying, say in the 1980s, 90s, the heyday of this, that that's not the traditional conception. But my article argued that that was a creation of the 80s and 90s that had a purpose. And it was not just pulled from history as the courts were suggesting. So one thing that article did was look back to the 1960s and the 1970s when we started to first get protections against sex discrimination, and show that the understanding in that period was not at all this formalistic conception. Again, just like in the First World War period, very ambiguous what sex discrimination meant. And two, it had much more to do with breaking down subordination and the enforcement of sex roles than it did with this formalistic divide. So things like sex segregated sports, not considered sex discrimination, discrimination against married women. We have a lot of contestation about whether that counts as sex discrimination or not. Protective labor legislation where women weren't allowed to work the same hours as men. There was argument about whether that was sex discrimination. Obviously, it divides between the sexes, but it was seen by a number of people in that period as benign. So there were plenty of courts finding that it wasn't discrimination on the basis of sex. I even came across people in the 60s arguing that sex segregated help wanted ads were not sex discrimination because they were just convenient and they helped employers and employees find each other and it wasn't sex discriminatory. Obviously that those draw a formal dividing line, but that wasn't the metric people are using in the 1960s to determine what counts as sex discrimination. So I borrowed this concept of an invented tradition from the intellectual historian Eric Hobsbawm. He wrote about the ways in which cultures invent traditions. He has some great stories about Scotland invented these tartans, the plaids that they use, that they say came from ancient clans. They invented that much more recently in a period in which they were trying to establish Scottish nationality and nationhood. And this was a convenient, quote unquote, tradition to try to accomplish a current goal. And my argument in that article was that courts have invented this tradition because they have normative views that it is okay to discriminate on the basis of sexual orientation and gender identity. And therefore, this traditional concept of sex comes in to say that these people can't be covered, but that is a construction of the later period and of the courts to do some work. Okay, now, as you probably know, and now I'm getting to the paper that's the subject of today's talk, 2 years ago in Bostock, the court reversed 50 years of precedent. It reversed all the cases that I'm talking about in Bostock v. Clayton County. And it held that, in fact, the Title VII of the 1964 Civil Rights Act that bars discrimination on the basis of sex actually does bar discrimination on the basis of sexual orientation and gender identity. After 50 years of saying it doesn't, now the court holds that it does. I'm going to pause for a second and give my 2 cheers. Yay, yay, right? 2 cheers for that. That was an amazing decision. Hundreds of thousands of people are now covered by this landmark civil rights law who weren't covered the day before. Our plaintiffs in the case are vindicated. I think the result vindicates the equality and the humanity of gay and transgender people. And so please understand that I have been advocating for this holding for my whole career, and I support it enormously. The court also cited the article that I was just describing to you, my Invented Tradition article. Court cited it numerous times in Bostock. So that was a happy thing too. But I will tell you what I'm going to talk a little bit about today is the court wildly distorted what I wrote in that article, what I argued, that the history shows. And instead of adopting a kind of subordination or stereotyping approach, maintained this formalistic view of discrimination that I am both critiquing on normative grounds and saying the court invented to do certain kinds of rights restricting work. And I actually think will in the future continue to do rights restricting work, even though in this case, it came out the right way. Okay, so let me say a little bit, for those of you who haven't read the decision in Bostock, the court adopted a methodology that a lot of the justices now subscribe to called textualism. And what textualism says is, you don't look at the purpose of a law. You don't look at the intention of the legislators who were passing that law. Like, were they trying to increase civil rights? Were they trying to enhance equality? You don't look at those purposes or intents. You look instead at the literal words of the statute. And from those words, you ask how they would have been understood by the public in the period that the law was passed, and you have your meaning. The selling point of textualism for the court is, according to the court, there's no judgment. There's no subjectivity, there's no normativity, there's no courts making judgments about what's covered. The words just give us the answer. And the court says, in this case, if you just look at the words, no discrimination on the basis of sex, you have your answer. Gay and transgender people are covered. If we had been good textualists all along, we would have seen that. We got it wrong for 50 years. But if we had just read the words of the statute, we would have had our answer, and gay and transgender people would have been covered. And the court's reasoning there is, if you say John can date Jane, but Sue can't date Jane, you have discriminated between John and Sue on the basis of sex. So that is sex discrimination. Likewise, if somebody labeled female at birth is being allowed to present as a woman and wear dresses and say that her gender is female, and someone labeled male at birth is not being allowed to do that, that's sex discrimination based on the sex that these people were labeled at birth. So QED, we're done. That's the decision in Bostock. That Title VII covers gay and transgender people. If you look in the dictionary, you will know that. And formalistically, we have our answer. I obviously think the court reached the right result there, but I think its reasoning was not only wrong, but quite dangerously wrong, and will have negative effects going forward. So let me talk a little bit about this. Okay, so Justice Gorsuch says that if you look in the dictionary, it says you can't discriminate on the basis of sex. That means there's a simple test for sex discrimination. You can't treat one sex differently or worse than another sex. The end. The reality is that is not an objective test that anyone can apply without exercising judgment. And it's not true that we interpret anti-discrimination law in this strict anti-classificationist way, or that the words of the statute can just tell us what counts as sex discrimination. I'll give you a couple examples. Sex-segregated sports teams certainly treat the sexes differently. Girls are allowed to play over here, boys are allowed to play over here. Title IX, the federal statute that bars sex discrimination in athletics, does not consider that sex discrimination. Likewise, every time the FBI and other governmental organizations' sex differentiated physical fitness standards have come before courts, men have to do 10 pull-ups, women have to do 2 pull-ups. The courts have held that that's not sex discrimination either, because those metrics are gauging peak physical fitness levels in both sexes, and 2 pull-ups is peak physical fitness for women and 10 pull-ups is peak physical fitness for men. So you have to have different numbers of pull-ups to get equal treatment of men and women. Or consider sex segregated bathrooms. If you leave aside transgender people for a moment and just consider cisgender people, if Jane goes into the women's room, that's fine. If John goes into the women's room, he can be fired, and the court does not hold that that is sex discrimination, even though it divides the sexes along a formalistic line and treats them differently according to their sex. So my article goes through quite a lengthy investigation of all of the ways in which courts actually have to use judgment about, and do use judgment about, what counts as sex discrimination, and shows that they actually are basing their judgments on what counts as sex discrimination on normative evaluations about what conduct is subordinating and what conduct is not subordinating, what conduct forwards gender stereotypes and imposes gender stereotypes on people, and what doesn't. And although in some of these cases, the court says we're just applying a simple test, the reality is they only apply the simple test sometimes. Sometimes they hold that grooming, sex differentiated grooming requirements, for instance, are not sex differentiation. And that has to do with their judgment that these practices aren't actually subordinating. Ditto the bathrooms, ditto the sports teams. Right? We don't have a regime that actually applies this simple test, that actually says you can't draw a line between men and women and treat them differently. Right? So when the court is coming in Bostock and saying, oh, we have the simple test, you're treating men differently from women because you're allowing men to date women, but you're not allowing women to date women, or the example, the similar parallel example in the transgender context. My argument is you need something else. You need to explain why in this context, you're actually now applying this simple test when there's a whole other range of contexts in which you don't. And the real answer is the gay rights movement, the transgender rights movement, all of the work that the Williams Institute does, all of the social change, all of the hours and sweat and tears and risk and work that people have put in for decades to change Americans' minds about the validity of discriminating against gay and transgender people. And that has been overwhelmingly successful. That movement that many of you are a part of and that have done so much work toward, that is what got us Bostock. That is what changed people's minds. That is what enabled the court to say that Title VII, the landmark sex statute that bars discrimination in employment, covers gay and transgender people. It's a judgment about the perfidy of discriminating against people solely on the basis of their sexual orientation or their gender identity. And the court's view that, unlike some of the things that it still allows that discriminate formalistically on the basis of sex, that this one is going to be moved into the category of illegal. The problem is the court didn't say any of that in its opinion. It said, and here I'm going to talk a little bit about what the court says and why I think it's problematic, right? the court said, we don't need to engage in any judgment, in any normative values, any cultural values. We're not even really making this determination because we're textualists and the statute demands this result. So let me describe a little bit about how this interpretive methodology works and why I think it's a problem for gay and lesbian and transgender people, for women, for racial minorities, and ultimately for our democracy. Okay, so I've told you that textualism says we're just looking up the word sex in the dictionary. That tells us that you can't differentiate between men and women. SOGI discrimination does that, QED, we're end of case. Okay. One of the projects of my article is to show that there are 1,000 what I call shadow decision points, little unacknowledged places where judges are making supposedly methodological, but actually outcome determinative choices in the course of a decision that leads to the result that they favor, but that does so in a way underground and doesn't tell us how they actually reached the results. So here's what I mean by shadow decision points. It turns out which piece of text you subject to textualist analysis can greatly alter the meaning of the text. This is something that Victoria Nurse at Georgetown and Bill Eskridge at Yale have written about it. They call it gerrymandering the text. The choice of what text you choose to look up in the dictionary or subject to textualist analysis can change the meaning of the statute. What sources you look at to determine the meaning of the text. Sometimes judges look at dictionaries. Sometimes they use these corpus linguistics databases that compile a lot of literature from a period. You plug in the keyword and it pops up, a couple hundred results from that period, from newspaper uses of that language in newspapers and magazines from that period. And from this, you're supposed to be able to see how the word was being used in that period or how it would have been understood. Let me just say a little bit about this. On the dictionaries, one, there are a lot of dictionaries, and it turns out that dictionaries have different definitions, and they order their definitions differently. And you can choose a definition and a dictionary that conduces to your preferred outcome and avoid those that don't. Similarly, with the corpus linguistics databases, it takes a lot of evaluation and judgment to say how those snippets of text that you're getting from the 1960s are using the term discrimination. So the court says discrimination means treating all women and all men differently, but my research assistants and I plugged in those words and we interpreted the texts that were coming back to us differently. There's a lot of interpretation involved. There are questions about how literally you take the definitions, about whether you find the text to be ambiguous or clear, because textualists say if the text is clear, then you just apply the dictionary meaning. If it's ambiguous, then you can start applying all these other sources, history and purpose and intent, and that determination of whether you're going to bring in all those other sources and potentially really change the meaning of the text is, again, a matter of judgment. I could go on at some length, and in my article I do, but my point is there are a lot of shadow decision points, many little points in a decision where you can gerrymander or reach the result that you want based on the choices you're making about how to interpret the text. So I'll just say one example is my article shows that in Bostock, Justice Gorsuch, who wrote the opinion, he consults one 1954 dictionary that defines discrimination in this formal anti-discrimination can't treat men and women differently way. That dictionary is from 10 years before the passage of the statute that he's interpreting, which is a huge no-no if you're trying to get the word as what it meant in the period. Why does he use that one dictionary? Well, it orders the definitions in the way that he likes, because if you start looking at dictionaries in the 1960s, when the statute was actually passed, they lead with a more anti-subordinationist definition of discrimination that says you can't hurt a subordinated group. That is a very different definition of discrimination. It's one the dissenters in Bostock prefer because it's harder to say that discrimination against gay and lesbian people stems from the subordination of women. Justice Gorsuch wants to avoid that, and he wants to go with a formalistic definition that says you're just treating men and women differently, because then he can do his formal analysis of John and Jane and who they're dating, and it looks like gay and transgender people are covered. Okay, the upshot of all of this is is a couple of things I want to say in conclusion, which is I think it's extremely problematic that the court is engaging in textualism and not providing the real reasons for its decisions. I think it's a problem for democratic accountability. The whole point of textualism is that there's supposed to be a conversation between the courts and Congress, where the court interprets a statute, Congress can tell us what they actually meant, and there's a dialogue. But when the court interprets the statute in such a way that they don't really tell us where they're getting their answers, it impedes that dialogue. When we have Supreme Court confirmation hearings and a judge just says they understand statutes by looking up the words in the dictionary, right? They're not really telling us what their judicial commitments are, what their values are, what their true interpretive choices entail. And we can't judge whether this person seems like someone we should appoint to the federal bench. And there are also extreme rule of law problems. Because this is so subjective and can be applied differently in different cases, it is simply unclear where going forward this will be applied to protect women or to protect gay people or to protect transgender people, and when it will not be applied. And in fact, Bostock ends by saying, there are a whole bunch of places this may not apply. This may not apply in locker rooms. This may not apply in bathrooms. This may not apply in sports. This may not apply if religious people object, et cetera, et cetera, et cetera. It just enables the court to make a lot of subjective decisions about the reach of anti-discrimination law without telling us what principles it's using to reach those decisions, right? It's constructing an understanding that enables it to engage in subjective judgment without telling us it's subjective judgment. So we could engage in that conversation more easily. I'll just say as a side note that the court in Bostock cites a lot of the history that I found when I was writing my previous article, including history from the EEOC, which was created by Title VII in the mid-1960s, and it was starting to interpret its anti-discrimination provisions. And I found an EEOC commissioner saying that the meaning of sex discrimination is utterly mysterious and difficult to control. And he was saying, it's mysterious because we don't actually know what sex is. There's no set meaning of sex discrimination. It could mean a lot of different things. So the court cites that EEOC commissioner, but it takes out the part where the commissioner says the meaning of sex is mysterious. We don't really know what it means. And it puts an ellipsis there. And it says, and just quotes the part where he says it's difficult to control. And the court suggests that the commissioner was saying, if you bar drawing a line between men and women, that could have radical implications like today's decision. But that's not at all what the commissioner was saying. He was saying, we don't know what sex discrimination means, and we're going to have to make some judgments, in part based on normative values about what we think should constitute discrimination on the basis of sex. And the court in Bostock absolutely does that, but it doesn't tell us that it's doing that. It just embraces this formalistic understanding. The final thing I want to say is, when I read Bostock and got to the end, one of my first thoughts was that this case is really gearing up for the affirmative action decisions, because the court in Bostock tells us that discrimination is formalistic, that it's anything that discriminates on the basis of a protected trait and draws a line on that basis, whether it be Jim Crow or whether it be affirmative action, whether it be discriminating against women as a group or discriminating against gay and transgender people, as long as it divides along that trait, it's going to count as discrimination. That account of discrimination in Bostock is the account of discrimination that is going to eradicate affirmative action in this country, likely next year when the court takes up the Harvard and UNC cases. And I would not be surprised at all if they cite Bostock and they cite this formalistic definition of discrimination that the court used in this case to protect gay and transgender people. But I am quite sure that they will use in the future to remove any attempts, any formal facial attempts by universities to include people who have been historically excluded from universities. And when the court does that, it will say the same thing it said in Bostock, which is, we don't own this. We're not making any judgment. This is simply what the law says. And look in the dictionary and you will see that affirmative action is illegal. And I think it is dangerous in a democracy to have these unelected judges not giving the real reasons for their decisions. And I think it is problematic that they have embraced a theory that will enable them to implement an entire normative agenda without admitting to people that that's what they're doing and allowing people to criticize that and to engage with that on those terms. Okay, so that's the end of my speech remarks. I would be happy to take questions from anybody.
Hi, Professor Franklin. Thank you so much for your detailed talk. We have a question here in the Q&A. In your view, what would the perfect Bostock decision have looked like?
Yeah. My inventing the traditional conception of sex discrimination article goes some way toward sketching out what that would look like. It was trying to actually envision Bostock before Bostock happened, and it sounds quite different than Bostock sounds. And here I want to say, I don't disagree with the idea that discrimination against gay and transgender people discriminates on the basis of sex in the way that the court said it did. I agree with that. I suspect that that's why Justice Gorsuch brought along Justice Kagan and Justice Sotomayor, because it's not wrong. It's just completely inadequate to explain the outcome in this case relative to other cases and to let us know what's really going on. So I would have written, say I would have written a concurring decision in Bostock that would have said that the meaning, that would have correctly quoted the EEOC commissioner and said that from the moment this was passed, what it means to discriminate on the basis of sex or discriminate on the basis of race requires some judgment. It cannot be determined by looking up in the dictionary, but that all of the historical evidence, if we're going to look back to how it was understood at the time, shows that the people who passed it and the people who implemented it and regular Americans who were arguing in the newspapers understood that this statute was disrupting traditional forms of discrimination and subordination on the basis of sex. And then over time, we have come to understand that discrimination against gay and transgender people, although it is also other things, is sex discrimination in the sense that it reinforces traditional sex stereotypes about what men and women should be, about how they should act, about what they should wear, about what characteristics they should embody, about what jobs they should do. And we have decades and decades of sex discrimination doctrine saying that that kind of reinforcement of traditional sex stereotypes is illegal. And although surely in 1964, the people who enacted Title VII did not believe that they were barring discrimination on the basis of sexual orientation and gender identity, they did understand that they were barring the enforcement of traditional sex stereotypes, and barring this kind of discrimination today is well within the ambit of that 1964 statute, and in fact, is the proper and best reading of that statute. I'll just say one more thing. I would have talked about the gay rights movement. I would have talked about the evolving understanding. I would have talked about why this is a matter of dignity and equality and liberty and all those good things and people's rights, because I would want to set a marker for this being a precedent going forward in how we think about discrimination against gay and transgender people. One of the big problems with Bostock is it simply says, look in the dictionary, this is formal discrimination. It really doesn't tell you anything, why we would protect against these forms of discrimination, and my opinion would have done that.
Fair. And as a follow-up to that, can you please comment more broadly on some of the choices made in litigation theory? Somebody is questioning if this textual argument, as it was decided in Bostock, it creates such a win for LGBTQ equality, but it comes with such a huge cost. Should we be avoiding these arguments entirely so that we don't make bad law? Or are there areas where these textualist arguments have a lot of value?
Yeah, I think that's a great question. I think that there's some role morality here. And then if I were a litigator arguing this case in Bostock, I would have done what the litigators did, which is they made the formalistic argument. They made the subordination argument. They made the stereotyping argument. They used history. They used the dictionary. They used all of the arguments that were available. And I think that was the right way to go. And I think they particularly included the formalistic and textual argument because they knew that this court is increasingly textualist, that Justice Gorsuch might have been swayed, as indeed he was. They were right by this understanding. And again, I don't think it is an incorrect argument. I do think it is sex discrimination, even on a formalistic level. I just don't think that gets us very far because formal sex discrimination is okay lots of places. But I don't think that in itself is a problem to say. I think that it is so important to win this victory. I think it is so important to have Title VII cover gay and transgender people. I think, it opens up some real possibilities for arguing in other areas of the law. The Biden administration is now looking at all the federal statutes and seeing whether every time sex is barred, SOGI discrimination is also barred. That is an enormous accomplishment. It will change people's lives. It will have excellent knock-on effects. And I think it was the right thing to do to make all the available arguments if you're a litigator. I think it was good that they pushed the other arguments. I wish that there had been a concurrence. I think I can understand why justices on the court who really wouldn't have written the opinion this way, but would have written it more in the way that I described, just decided to let there be a majority opinion, to speak loudly with one voice. But I think it would have been helpful to have a concurring opinion that said some of the other arguments. But I just don't think it's wrong for litigators to have used this powerful argument that could persuade the court because they're trying ultimately to win the case for their client. And again, I don't think it was a wrong argument. And it's not as if we hadn't had Bostock, affirmative action would have lived. It's not the case. And so I guess I would say, let's try to make better arguments. Let's have discussion about this. But ultimately, I'm not going to condemn a litigator who makes an argument within the rubric that the court has laid out for the last 50 years as what the doctrine says.
What do you think is left of sex stereotyping theory after Bostock? Do you think that argument can still be powerful in SOGI cases?
Oh, absolutely. Yeah. I see. That's why I'm saying I don't think it was a problem to make it. The formalistic argument that, John can't date Steve, but Jane can date Steve, that argument doesn't preclude the sex stereotyping argument. It in no way forecloses that argument. In fact, I think it probably just gives more of a platform for that argument because now you can say, well, why is this formalistic discrimination wrong in this context, but maybe not wrong in some other context like sports or, wherever you think, if you believe there can be sex classifications in the law, some people don't, but most people do. Now you have an ability to explain why Bostock is different from those cases. In other words, the opinion is so spare and doesn't and leaves so much out that I actually just think you can go forth with all your stereotyping arguments. They're completely complementary and they're in no way foreclosed. And I very much hope that we do that.
Looking to the future, how do you think that the court might chip away at Bostock in the near future?
Oh, yes. It's how will the court chip away at Bostock? They absolutely will. There are several grounds on which that can happen. So one ground is other competing values in the law, like privacy and safety. So I can already imagine a decision, because lower courts have already said, even if you view, say, in a locker room context or a sports context, you see that it's formal discrimination, say against a transgender person, well, we have competing privacy values or safety values on the sports field that are going to outweigh the discrimination involved in that case. And the big one, which the court very tellingly nods to in Bostock, is the religious exemptions. So as you probably know, the court is carving out major exemptions all across anti-discrimination law for religious employers or religious state actors who want to discriminate on the basis of sexual orientation and gender identity, and saying that those protections for religion trump anti-discrimination protections. We're going to see that left and right. It's already happening. It will seriously limit Bostock.
Do you think that Bostock's ruling is going to have any impact on whether SOGI claims are given intermediate scrutiny under the Equal Protection Doctrine?
Oh, that's a great question. Yeah. Yes. So I think that Bostock, along with a number of other decisions, including the same-sex marriage cases, means that although the court didn't say it in Bostock, we're now, in many instances, not actually applying rational basis review when we have discrimination on these grounds. We've particularly had cases, sexual orientation cases, like Romer v. Evans or Lawrence v. Texas or Bergefell v. Hodges. Those of you who've taken con law or a sexuality in the law class will have read those cases where the court really is applying something a little more heightened. I think Bostock will just add to that list of cases where the court has made it clear that we have some sort of higher concern when folks in these groups are being discriminated against, because there is this history of discrimination. Numerous circuits and state courts have already held that there's either strict scrutiny or intermediate scrutiny on the basis of sexual orientation, gender identity. I don't think this court, because of its composition, is tomorrow going to declare strict or intermediate scrutiny on the basis of sexual orientation or gender identity. I'd be very surprised. But that has to do with the court personnel and not, I think Bostock pushes in that direction, which is why I'm not really upset with Bostock or the litigators in Bostock. They got something like a Rorschach blot on which you could argue that what this meant, what this essentially was a kind of heightening of concern or heightening of scrutiny if we go into the constitutional context, or a statement by the court that this kind of discrimination isn't okay anymore. You could build and say what Bostock really means, and that would be applicable in the constitutional context. I think that will work in some courts that aren't the Supreme Court, and may work at the Supreme Court when the personnel turns over. But I just don't think we'll see it tomorrow, given this court.
You've been talking about how this current court is embracing textualism, but are there any recent cases that you can think of where the court has rejected textualist arguments out of curiosity?
Well, actually, I'll say this. I think the court, well, first of all, there are textualist arguments on both sides in most cases. So the court is rejecting textualist arguments that it doesn't agree with. But even more pointedly, I would say sometimes, and in some contexts, absolutely the court just doesn't apply textualism. Brnovich, the voting rights case, check it out. The text is pretty clear. The court just completely ignores it in favor of a reading that allows it to gut the Voting Rights Act because that's the outcome it prefers. It's quite egregious to look at Bostock and Brnovich next to one another. I will also say, actually, that historically in the affirmative action context, textualism and originalism tends to fall by the wayside because the history actually doesn't look so good in those cases. My own view would be that the history of the public understanding in those periods would allow for some racial classifications. And thus far, the court has not really been textualist originalist in the affirmative action cases. So stay tuned for the affirmative action cases, or look at the old ones, look at the voting rights cases. The court applies textualism when it sees fit, and that's part of the problem.
How do you think that the decision in Bostock is going to impact future court decisions in trans sports bans in particular?
I believe that Bostock should be a major platform and a powerful argument for the rights of transgender people to play on the correct sports teams. I think, however, and here's where I'm saying, the decision I would have written in Bostock would have talked about the history of discrimination against transgender people and made it clear why that is wrong and what it has looked like and why we're rejecting it. And that would have been more useful in the sports cases. I think because the decision, particularly when it comes to transgender people, it barely talks about transgender people at all. Most of the argument has to do with gays and lesbians. It's sort of like, oh, and transgender people. And it just has this very spare formalistic look up in the dictionary kind of approach. And then ends with, and the dissent is full of discussion about, countervailing values, that Bostock doesn't provide as strong a foundation for arguing in the sports cases as it might have if it were written otherwise. But go to it, lawyers, go to it with Bostock. Bostock says it is discrimination to treat transgender people worse than cisgender people. And I would hammer that principle home in those sports cases. And I think in some courts that will prevail. But I certainly don't think one should view this as a slam dunk. I don't think Bostock will just, it's Bostock plus a lot of work to get victory in the sports cases.
All right. Well, that is all the questions we have right now. Thank you so much for taking the time to speak today. This has been so excellent and eye-opening. I think that's it. Yeah.
All right. Thank you so much, everybody. Thank you for listening. And thank you for caring about this and doing this work. I'm really honored to be here.